This is Greenwood's Legal's Employment Law Nowcast, episode 11. This is the second part of the case law quiz. Enjoy the podcast. Hello and welcome to the latest episode of our Employment Law Nowcast. Today we are bringing you some more questions from Keith's case law quiz. And I say some more because if you've watched our previous episode, you'll know that there were 3 questions last time. I'll be interested to know how you got on, and I would be especially interested to know if at the end of this episode you've got a grand total of 6 out of 6 right. If that does happen, let us know, because some of them are tricky lawyer questions and that is no mean feat. Good luck.
Continuing to move on. Question 4, and this is about employers' knowledge of a disability. You refer an employee on sick leave to occupational health. The occupational health report doesn't suggest disability, indicates the employee will be able to return once there's a resolution of workplace pressures. You seek further medical advice, but the employee resigns and brings a claim of disability discrimination and constructive dismissal before you get that advice. A subsequent medical report shows that the employee's disability, and it is a disability, stemmed from a mental health issue, something that neither party had previously known at the time. The employee's stress had been noted throughout and was mentioned by colleagues and GP notes, but it wasn't considered to be an indicator of mental health illness, but rather a trigger for headaches. So, the employee's brought a claim for disability discrimination, can she? And we've got our 4 answers. Yes, the employee was disabled. It doesn't matter that neither she knew the employer nor the employer were aware. Or no, the employer didn't have actual or constructive knowledge of the employee's disability. Or C, yes, the employer was aware that there was ongoing health issues, so should have been aware that the employee could be disabled and should have acted accordingly. Or D, no, a medical report had been obtained which contained no medical diagnosis of disability, so liability could not attach to the employer. We've got overwhelming 3/4, so 30 out of the 40 people that voted say yes, the employer was aware that there was ongoing health issues, so should have been made aware the employee could be disabled and should have acted accordingly. You have my sympathy. If I hadn't specifically read this specific case for these purposes, I think that's the answer I'd have gone for as well. But it's employment law. It always has the capacity to surprise. And the correct answer is, in this case, no. The employee did not have actual or constructive knowledge of the employee's disability. Yep, I'm as surprised as you are, I think. This is the case of Lingard and Leading Learners Multi-Academy Trust. It's an EAT decision. And the facts are very much as they were. So we've got a head teacher and then the executive head of the Multi-Academy Trust. And the head of a primary school felt that she'd been pushed out of her job by aggressive, hostile and unsupporting behaviour. There was no dispute at the time that there were some health issues going on, so the employee had a little bit of time off. Hypertension, stress appeared on the doctor's notes. There had been a previous occupational health report that said, well, there are health issues and these but nothing in that occupational health report indicated that there was a long-term issue or a disability at play. But it was so after the termination, a medical report did show that the employee was suffering from generalized anxiety disorder and that amounted, in the opinion of the report, to a disability. And in fact, before the case got to hearing, the employer had accepted that at that point the employee was suffering from a disability. But she was still unsuccessful in her claim for disability discrimination. And the tribunal found this, and the AT supported it, that even though the employer knew that she was suffering from stress, that didn't necessarily mean that they knew she was disabled. Interesting footnote, she did win her claim for constructive unfair dismissal. I sometimes think there is a little bit of a balancing act that tribunals do, and quite often, especially if they've got any sympathy at all for an employee, they will give them something to go away with, a sort of consolation prize. But she did win part of her claim here, so it's not that she went away empty-handed. She did win part of her claim. So she was constructively unfair dismissed, but the EAT and the tribunal found that that wasn't disability discrimination. So the takeaway point that we got from the tribunal on this is that the employer needs to know, and we'll come down to constructive knowledge in a second, needs to know that the employee's disabled. So they need to know that they have a physical mental impairment, that it's substantially long-term, and affects their day-to-day activities. And what they didn't know here, they knew that there was an issue, but largely the employee had been able to keep coming to work. They didn't know it was long-term, and it was debatable about how much impact it was having on her day-to-day activities, because she could largely function. So on that basis, and the fact that it was just stress, was what they said. The employer didn't have actual knowledge, and they didn't have, and this I think is the surprising bit of the judgment, they didn't have constructive knowledge. So they couldn't look at all of what was going on and put two and two together and think, hang on, there's a serious health concern going on here that we need to address. And until that has happened, all sorts of obligations aren't triggered. So no need to make reasonable adjustments is a classic one. But no dealing with the employee as a disabled employee at all. And I do think it's quite surprising, and kind of you have to be there in the tribunal to see why an employment tribunal have reached a particular finding of fact. But yeah, I remain slightly surprised that they found that there was no constructive knowledge here. I think if I'd been advised, I shouldn't say this because it sounds like I'm a terrible lawyer. If I'd been advising, I'd have advised the client, look, I think we probably need to assume that this person is disabled and treat her accordingly. Whether we admit she's disabled is a different matter, but all the warning signs there. What it does then, what the EAT did make a point of saying is it kind of sends the wrong message. It's, well, if you're in any doubt, act quickly, get someone out before you know that they're disabled. Because if you can say, "Oh no, I didn't know," then you're going to avoid the risk of a disability discrimination claim. And the more you find out, the more likely it is that you know that they're disabled. The EAT say, look, this is not sending a message to people that act in haste, turn a blind eye to conditions, because if you're seen to be doing that, then it's probably not going to end very well for you. But probably a slightly surprising case, all in all, that one. Moving on to question 5. Decision makers when dismissing. So again, slightly convoluted facts on this one, but bear with me, there is a point to it at the end. A manager and an MD raised performance concerns with a female employee. Shortly after they do that, she informs her manager that she's pregnant. There's some improvement in performance noted after the conversation about the performance concerns, but the employee then takes 2 days sick leave due to morning sickness, during which her manager discovers that she hasn't processed certain documents. The manager informs the MD that there are ongoing problems with employees' performance, without mentioning that the most recent issues are linked to a pregnancy-related absence. The manager then makes certain disparaging comments to the employee about her morning sickness on her return to work, following which the employee is called to a meeting with the MD, who dismisses her on performance grounds. The employee brings a claim that her dismissal amounts to pregnancy discrimination. And the question here, and we'll talk about why this becomes the important question here, is who was the decision maker? So we've got a little cast of the usual suspects. We've got the MD. He ultimately took the decision, so was the sole decision maker. We've got B, the MD, but influenced by others. The manager had influenced the MD to dismiss. So the manager's motivation should also be considered. C, the MD and the manager were joint decision makers. Or D, it's unclear on the facts currently presented, and further context is required to understand the dynamics and who ultimately made the decision to dismiss. So there are 4 possible answers, and we've got 50% went for D, and the other popular answer is B, the MD but influenced by others. The manager had influenced. People that said, hey, surely we're not going to do that to you again, say, dunno on the facts. Dunno, we're not monsters. Actually, we are monsters, yeah, we don't know on the facts. So the correct answer is D. On the facts, as the EAT have them, it's unclear who the decision maker was here. And when all said and done, if you're deciding about terminating someone's employment, who the decision maker is really quite important. And that is the lesson that we can all learn from this case. So this is the case of, I'm going to say Alcedo because it's a Spanish word, but someone correct my pronunciation if that was wrong. Alcedo Orange and Ferridge Gunn at the EAT. And it follows quite an old case, the Reynolds case, that really emphasises the importance of working out who the decision maker is, because if the decision maker isn't acting with any discriminatory motive, the decision can't be discriminatory, subject to a few things we're just about to talk about. So if someone is complaining that there's a discriminatory act, you've got to look at the person who did the act or made, in this case, the decision. Was that motivated by discrimination? Doesn't necessarily matter if there's something else going on in the background and someone else is maybe acting in a discriminatory way. Was the person who acted or made the decision acting from a discriminatory motivation? Or were they acting on someone else's motivation? Was someone else encouraging them along? What the claimant said in this case is that the manager's comments, and they were comments really quite disparaging about morning sickness, like, is it a virus? How long are you going to be off for because we can't wait around all day for you? That sort of stuff. Not the most supportive approach that the manager could have taken. That they were background, the claimant said, that sheds light on the ultimate decision taken to dismiss her. Now, what the Employment Tribunal didn't do here, and why the answer we've got is the right answer, rather than one of the others, is they didn't do any proper analysis, the Employment Tribunal, of who the decision maker was. And the EAT actually used the words, this case cried out for there to be a proper analysis of who it was that was the decision maker. Was it just the MD? Was it the manager? Was it both of them together? Was it the MD but influenced by the manager's actions? And the EAT really hadn't done, so the Employment Tribunal really hadn't done a very good job of that. And so what the EAT did was send it back to the Employment Tribunal to have another go. Again, it's like the previous case, another example of the EAT saying, look, there's not one inevitable factual outcome from this. It's not our job to decide what the facts are. Back to the Employment Tribunal to work out what the actual facts are and then make a decision. What they did do, though, they put the boot into the manager a little bit, who clearly, from reading the case, did not cover herself in glory, the manager in this one. And they said, oh, what you might want to do, claimant, is amend your claim to bring a discrimination claim specifically against the manager for their comments. So they managed to open up the case in that way. So what does this case mean for us? You can't discriminate if you don't know about the protected characteristic as an individual. As an organisation, you need to look at what the organisation knows as a whole, but individually, individual decision makers who don't know about the protected characteristic, it's going to be very difficult to pin responsibility on them for acting in a discriminatory way. And it needs to be that decision maker who is motivated by the discriminatory reason. What you can't do as an organisation is essentially put up a puppet decision maker who is just a mouthpiece who pretends they don't know anything, and you'll get away with that way. You won't get away with that because, as the E11 have said here, it's really important that the tribunal drill down. If there's any doubt as to who the decision maker is and whether there's knowledge, the tribunal needs to drill down and actually work out who the decision maker was. I think it's really important, and I do see it quite often, and I always think, no, this has to be sorted out. I see decision letters on dismissals drafted in quite an ambiguous way. So it's going to be signed at the bottom by the manager who was ostensibly running the disciplinary hearing and making the decision. And you see phrases like, we have decided that, or it has been decided that this amounts to gross misconduct, or whatever the outcome is. I always really like to see it set out in the first person. I have decided that. So I think that's a real, one small takeaway tip. If you've got someone who's a decision maker, they need to put their name to the decision. I have decided. It's not we. It's not it's been decided. It's not I have no option but to, because actually your job as a decision maker is to make the decision, not follow a policy and say, well, it says gross misconduct is dismissal, so that's what happens. So dismissing in particular, because that's where the flashpoints usually are, dismissing managers really need to take ownership of that decision and be prepared to say, I have reached this decision for these reasons. So if you take one thing away from this part of this morning's presentation, it's that, I would say. Moving on to the final quiz question before handing over to Michaela. So this one's about grievances and the without prejudice rule. So an employee raises a grievance complaining of mistreatment, pregnancy discrimination, bullying and harassment. You invite the employee to a preliminary discussion to which she brings her husband. Both of them are legally trained. At the meeting, you ask to speak without prejudice and no objection is raised. You make an offer to terminate her employment, but no agreement is reached. In the employee's grievance and appeal, she raises issues that they're both rejected. She resigns and brings claims of constructive dismissal and discrimination. The claim references the without prejudice meeting. Your solicitor applies to have those references removed on the basis that the meeting was privileged, it was without prejudice. So, is the employee able to refer to the without prejudice meeting in her claim? And our four options are A, no. The meeting was described as without prejudice, so under no circumstances can it be referred to in the proceedings. Or B, yes, she can refer to it because there needs to be a dispute for the without prejudice rule to apply, and a grievance is not a dispute. Is it C? No, the meeting concerned a grievance which involved a true dispute on the facts and litigation was a real prospect. Or is it D? Yes, she can refer to it. The settlement proposal constituted unambiguous impropriety, which is an exception to the without prejudice rule. So fairly even split here. Yeah, we didn't end on an easy one, did we? It's take your pick. So just about the favourite was no, the meeting concerned a grievance which involved a true dispute on these facts and litigation was a real prospect. So let's see what the answer was. And yes, well done, those just under 30% of you who went with that. The meeting was a grievance, decided the courts on this one, there was a dispute and litigation was a real prospect. So this is a case of Garrod and Riverstone Management. So Ms. Garrod was the company secretary. She was a qualified solicitor, and her husband, who she brought as her companion to the meeting, was a doctor of law. And in fact, the company here had offered to pay a contribution of £500 plus VAT if Ms. Garrod wanted to bring a solicitor to the meeting. They would make a contribution to those fees, but she turned that down and brought her husband instead. So back to the very basics. If you have a genuinely without prejudice conversation with an employee, the content of that without prejudice conversation can't then be raised in any future court or tribunal proceedings. It's been done as a genuine attempt to settle claims, and courts and tribunals, judges in general, like the idea of the parties being able to settle claims without resorting to litigation. So lawyers, and judges are lawyers, are quite keen on the without prejudice rule being honoured insofar as it possibly can be. But for there to be a genuine without prejudice conversation, you definitely need one thing in place, and you probably need something else as well. And there needs to be a dispute between the parties. And if there's no dispute, then it's really difficult to have a without prejudice conversation. And the other thing that you need, ideally there will be some contemplation of litigation. That's usually a big tick as to whether something's happening on a without prejudice basis. But you also really need there to be a genuine effort to settle the claim or settle any dispute for without prejudice to be triggered. Once it has been triggered, there are, and we'll come on to exactly how it can be challenged, but once it has been triggered, it is quite difficult for anyone to get over the without prejudice rule, and that should be a protected, that should be a private conversation. So Ms. Garrett in this one, she said, well, even if there was a dispute, which she didn't accept, there was no litigation in contemplation, so without prejudice shouldn't have been engaged. And the other thing that she said, which is the one way that if you genuinely do have a without prejudice situation, you can get round it if you want to, is where there is something that happens in that without prejudice conversation that is unambiguously improper. The phrase that you hear more often than that is unambiguous impropriety. So where there is unambiguous impropriety, you can get round the without prejudice rule. And that stems back from a case a little while ago, that phrase. And what you're looking at there is where without prejudice is being used to disguise perjury or really obvious discrimination or something else of that really serious nature. The EAT in this case went on to look at all the claims that the claimant was making, and old case law, previous case law, has focused more on, well, a grievance isn't necessarily a dispute. So just because there's a dispute, just because there's a grievance doesn't necessarily mean there's a dispute. They looked at it the other way here and said, well, just because it's a grievance doesn't mean it's not a dispute, and there can be a dispute, and it's very much fact dependent. And the grievance that the claimant had made here was really quite forceful. It raised serious issues about discrimination and associated acts, and it did refer to potential infringement of legal rights. Throughout the process, the claimant had suggested that perhaps ACAS should get involved. Again, the EAT thought, well, that suggests that there is a genuine dispute here, and what's more, that litigation might be in prospect, because why else might ACAS be involved? And the fact that both the claimant and her husband were lawyers, immediately they felt reasonably put everyone involved on notice that this might turn ugly, because I don't know if you've ever seen a bunch of lawyers in a room, it can frequently turn ugly. So the tribunal or the EAT were content that the boxes had all been ticked here for this being without prejudice. Yes, there was a dispute. Yes, there was litigation potentially in contemplation, at least. Yes, the conversation, even though it never actually went anywhere, was a genuine effort by the company to try and resolve the dispute. They didn't accept that the unambiguous impropriety threshold had been covered, had been cleared, and they said that once you have a without prejudice conversation, it should only be in the most unusual cases that that stuff can be brought in to a case. the hurdle for unambiguous impropriety is pretty high. It's got to be really very serious wrongdoing. So what the claimant said here, that, well, she didn't like how some things were said, and the offer she thought was trying to bully her into accepting her exit, that didn't meet that threshold at all, thought the AT here. So this is a positive one for employers. I think in particular the explicit statement that a grievance can be a dispute it's not automatically ruled out being a dispute just because it's a grievance. That's quite helpful. What does it mean for how we deal with these sorts of issues? Well, what it does mean is that you can, on a case-by-case basis, look at what the employee is actually saying in a grievance, and it may give you comfort that it triggers actually that there really is a dispute here. Yes, the employee's raised the grievance and we need to investigate, but there may be stuff that the employee's raised that clearly you as an organisation can dispute, and so that may be enough of a dispute that you're comfortable having a without prejudice conversation with them, using that cover of without prejudice to have the conversation. It's not a complete panacea calling something a without prejudice conversation, because despite what we've just looked at in this case, there are a number of hurdles that you need to get over for it to be without prejudice, and there are a lot of challenges that an employee can make to that. The other thing worth mentioning is protected conversations, which were introduced a few years ago in the Employment Rights Act, Section 111 of the Employment Rights Act. The difference between a protected conversation and a without prejudice conversation is that if you're going to have a protected conversation with an employee, there doesn't need to be a dispute. So you can launch straight into that without there being a dispute, and there doesn't need to be litigation and contemplation, etc. So it's a lot more user-friendly in that way, but the huge limitation to protected conversations is that they're only protected in relation to unfair dismissal complaints. So if you've got a situation where there's any angle of any sort of discrimination or whistleblowing, you can't hide behind a protected conversation to avoid those issues coming up. So you need to be really careful. A top tip that I have given to a few clients when they've asked that is worth bearing in mind is you don't really have to choose between having a without prejudice conversation and a protected conversation. The same conversation can be both. So you can call it a without prejudice and protected conversation. So you can sort of cover both bases there, which does give you a bit of extra protection. It can be tough to start these sorts of conversations with an employee, but sometimes it's a practical necessity. You've got an issue with a client, and actually the most pragmatic solution with your employee is to have that conversation with them. What I would say is, because you can't guarantee that things can never be repeated, there may be a way around them being without prejudice. That they may not be protected by the protected conversation rules because there's elements that might amount to discrimination in there. Just tread really carefully. You can set these things up to be as safe as you can. So what I would always say is be really clear with the employee if you are going into a without prejudice conversation or a protected conversation. Make sure that you can say, if you're ever sat 2 years down the line in an employment tribunal, that you can say, yeah, I was absolutely clear that the employee was prepared to go into that conversation on that basis, and that they knew what they meant. So depending on who you're dealing with and whether you think that they will understand really what you're talking about, you do be quite clear if you think you have to be what that means, that whatever we now discuss, you won't be able to bring up at a later date. It's only for the purposes of having a discussion around resolving the dispute or settling the claim or negotiating the exit. And once you're through that sort of firewall of you've started the conversation, still actually think about what you're saying and don't say things that might be inflammatory or might amount to discrimination, because if that envelope gets pushed too far and you are in the realms of unambiguous impropriety because of something you've said, then you're not going to get the protection in any event. So just because you think you're talking about prejudice, it's not. All rules are gone, all bets are off, the gloves are off. Do still be mindful of what you're saying, because it could come back to haunt you.